welcome another very accomplished guest, Mr. Anand Prasad. Anand is a corporate and commercial lawyer with more than 25 years of experience representing both domestic and international clients on a variety of legal and commercial issues. He was a co-founder of TriLegal, one of India's leading full-service law firms. He quit that to help establish the Liberal Party of India to promote values of individual liberty and a free economy in Indian politics. In 2019, Anand returned to private practice and established APN Partners. He now specializes in advising boards and senior management of companies on dealing with difficult corporate, commercial, governance, and compliance situations. He also provides advisory and structuring support to businesses on investment, mergers and acquisitions, and financing transactions. He has a good understanding of evolving government policy and has advised clients on cross-border transactions, establishing joint ventures, bankruptcy, regulatory issues, and corporate fraud and corruption situations. Other than being a lawyer, Anand has a keen interest and spends considerable time studying ancient Indian history and is in the process of penning a book on this topic. Welcome, Anand.
Thank you, Archana.
So, Anand, should we start?
Yeah.
Okay, great. So, we'll start with what's happening in India now. What's force majeure and how does it work?
So, force majeure is a Latin term, but essentially it points to a situation. So, in a contract, so I'm going to the very basics of what the concept is of force majeure. So, in a contract, you have one or more parties that actually enter into a contract. Each one of them is required to perform some parts of what they contract to. And force majeure is a situation which is external to the parties, something that is external that prevents one or both of the parties from performing their parts under the contract. And under contract law, typically, if a party is prevented from performing his contract by an external situation, that particular party who is prevented can claim that, look, I can't any longer perform the contract, and therefore seek an exit from the contract. So I'm not using technical terms, but basically you can seek a termination of the contract because you are not able to perform. On the other side can say that you're not performing and therefore let's terminate the contract. A force majeure clause is a provision that you insert into a contract to deal with situations like that. So a force majeure clause will say, all right, if there is an event of this nature, then one side will continue to perform, or the entire contract will be suspended, or we will actually terminate the contract. So it could provide for provisions to deal with a situation like the current pandemic. So that it's a lot of legalese, but that really is what a force majeure is. It is the occurrence of an event which is external to the parties to the contract that prevents the parties from performing the contract. Now, if you have questions on force majeure,
I mean, how can it be applied in times like now? Can it be applied under the Indian law?
So let's say that take the easy situation of an employment contract. An employment contract will say that on every working day between 9 to 5, you'll show up at this office. Now, this is a force majeure situation because the law prevents me from stepping out of my house and therefore performing my contract. An employer can say that, look, you're not performing your contract. I can understand that it is not a breach of contract, but really the contract has come to an end because you are not able to perform your part of the contract, and therefore I will treat the contract as terminated. So that is how you will look at force majeure, unless between the contract, between the employer and the employee, you come to an arrangement which is either that arrangement you put in place now when force majeure happens, or you have already put it in place that when a force majeure happens, then my requirement to perform will stand suspended. Your contract could say, for example, it could say that my requirement to come to office and work is suspended. your obligation to pay me is suspended until the time the force majeure situation goes away and I can start performing my contract once again. That's one kind of contract. The other kind of force majeure clause could say, I don't have to come to work, but you have to continue to pay me. And I will rejoin work whenever the force majeure is lifted, provided, and unless the exception is that if, say, the force majeure continues for beyond 2 months, in which case we can actually terminate the contract. So a force majeure could actually be operationalized in a manner where you say that for a limited period, you will modify the contract to a certain degree, but if the force majeure continues, then there's no reason really to continue with this contract, and you will actually terminate it. So that is in a limited employee context. That is the way you would work.
Mr. Pant is asking, in case the clause is not part of the contract, can one still claim inability to perform their part of the contract?
So inability to perform the contract has one consequence, which is that the contract ceases or it terminates because the contract is frustrated, which actually results in a termination situation. So force majeure clauses typically, if you don't have a contract, then, or if such a clause is not there in the contract, the clinically it actually results in termination. The question is, we want to keep the contract alive beyond the force majeure situation. Either you have a past contract, or when the force majeure situation happens, you then enter into a contract. Now, it is the other side has to agree, or the law has to provide for a bridge that actually results in the contract not getting terminated. In today's world, we have no law that actually bridges the gap that allows the contract to survive the force majeure event. So today you will have to actually either reach out to the other side to say that let's get the contract to survive, or even after the pandemic is done, by conduct, you can actually function as if the contract has survived. But if the other side, if both the parties to the contract, all the parties to the contract are not willing for the contract to survive the force majeure, you can't actually force the continuance of a contract.
Great, thank you. What is the effect of lockdown on the Indian judiciary? And are we working more on use of technology in our judicial system? I mean, of course we are, but to what extent?
So what has happened is, I mean, all of us are under lockdown, as are the courts. There are certain government functionaries that are allowed to go and perform and continue to operate. But what the force majeure situation has done, the courts have realized that it is going to be dangerous to allow for a bunch of lawyers to show up in court, because they could also transmit the disease. The judges could get infected. So what has happened is, at least the Indian judiciary has migrated to using video conferencing as a method to hold court. So your physical appearance is not needed. You are sent a link, you connect into the link through a video conference, you present your arguments, and then they pronounce judgment. So they've started using technology through video conferencing. Now, of course, we are not all set up, and this is an emergency situation. So they're doing it in exception-only cases. So in cases that are very critical or that are urgent, they are doing it. In most other cases, they are actually putting off to the period when the lockdown is over. However, what judges have, or at least the Supreme Court has said, is that the lower judiciary should also look to use technology in this particular fashion of video conferencing. And it is quite possible that video conferencing or holding courts through video conferencing will continue beyond the pandemic and beyond the lockdown. And actually, in my view, it will be a good thing, because it will actually help speed up the judicial process. It will help the judicial process become more efficient. And then many other aspects to what technology will do to how cases are presented in court, which probably lawyers will appreciate a bit more than...
I'm sure. No, everybody in all professions, I think this will make a big change. So Mr. Arvind is asking, what are e-courts?
Technically, there is nothing called an e-court today. What could happen is that this could, because today you have got something that is a physical court that is using video conferencing, but an e-court could become one where the filings are all electronic, and you do have in today's world the option of doing an electronic filing. But the filings all go electronic. The arguments all are made electronically. The arguments in court, that is written arguments, the arguments in court are made through video conferencing, and that truly would be an e-court. Today you've got facets of it as part of the system, but I would imagine that it will all go electronic.
So the Citizenship Amendment Act, it provides Indian citizenship to minorities who had migrated from neighboring countries before 31st December 2014. So why does the Office of United Nations High Commissioner for Human Rights find it fundamentally discriminatory? And what flexibility can be provided according to you?
So this is but it's very loaded politically. But I'll sort of say it the way I see it. Whether part of my politics is part of my answer, I can't really sort of make it more neutral than that. But I'll try and stay as neutral as I can. So when you look at the CAA, before and as the CAA suggests, it is Citizenship Amendment Act, which basically means that there is a citizenship law. This is just an amendment to it. So the question is, how do people get citizenship? And you get citizenship by birth, you get citizenship through various processes that were there in old system. And if you're a this amendment says that if you the discriminatory part is that it says all other religions, it sort of identifies all religions, and it actually leaves out the Muslims out of it. So the question is, if you are granting automatic citizenship to people that come from neighboring countries into India, and the only guys you will not grant citizenship to is the Muslims, then it is discrimination on the basis of religion. And there could be arguments to say that, look, in the first place, nobody is entitled to automatic citizenship. No country anywhere around the world grants citizenship like that. So the US doesn't, Western Europe doesn't. They have got immigration standards. You got to go through a tedious process to get citizenship. Even in India, you have a tedious process to get citizenship. This is an additional provision that is allowed for immigrants from the neighboring countries, from minority communities. So from a theoretical perspective, it does look that there is one section of an immigrant community, which is on the basis of religion, actually do not grant them citizenship. It begs the question as to why should India grant citizenship to anybody at all? How can the rest of the world insist that you should be granting citizenship to one or other community? I think there's a bit of an aspect of who are other countries or the rest of the world to tell India who should India be granting citizenship to and who we should not be granting. So that is the sort of legal debate, and from a constitutional perspective, my own view is that it will be it'll go through.
What are your views particularly?
Discriminatory. I'll tell you the discriminatory part, and the argument from the government has been, look, this law is not taking away any Muslim citizenship. So why are Indian Muslims getting hassled with this? And actually, the government is absolutely true, because this particular law is not taking away anybody's citizenship. The fear is that there will be a following, I would call it law or a process in terms of the NRC that will start testing people for their citizenship. And the real problem lies in the NRC as against the CAA. I think in the CAA, the only, if you would say, theoretical discriminatory aspect, it has no immediate implication in practical life, but in the mind space it is discriminatory, because let's say I was a Muslim in India, I would say, look, everybody else that comes from an immigrating from a neighboring country, you are actually giving citizenship to, and only if they are Muslims you're not granting them. So is there a problem with me? Because I am Muslim, and do you therefore, when you hold back citizenship for people because they are Muslims, should I feel that there is something wrong with me or something wrong with my religion? So it's more sort of theoretical construct like that. It doesn't hamper an Indian citizen who is a Muslim his life or any of his rights. It just sort of puts in a bit of a question mark, which might be a bit distasteful.
So we go on to the next question now. What do you have to say about the Sabarimala case, where women from 10 to 50 years old haven't been allowed inside the temple, and then what's the status of today?
So for Sabarimala, it's a slightly complicated situation. I think most of us would sort of think of the Sabarimala debate as a discussion or as a debate that is discriminatory of women. So does the temple or the rules regarding entry of the temple discriminate against women? So we see it in terms of an infringement of the right of equality, which is an Article 14 right, saying that all citizens must be treated equally, and here is this temple that is saying that citizens are not all equal. So first, we've got to realize that actually from a legal perspective, it is not an Article 14 debate at all. It is not discrimination against women as we typically understand it in a right to equality sense. The Sabarimala debate is essentially about the right of women to practice religion. So it's not one of equality. It is women saying that I have a right to practice religion by going to a particular temple. So again, it's sort of maybe more legal theory than what a layman would enjoy getting into. So that's the distinction. That the first distinction that I would make is it's a debate around the right to practice religion as against the right of equality, as most of us think of it. Even lawyers, when you ask them, do you know what the debate is about? They will say it's about the right to equality, and the answer is it is not about the right to equality. So this is a right that women that actually want to go to the temple, they are not allowed to exercise that particular right. The question is, what is this temple about? So when we think of temple, we think of temples in our neighborhood or the temples that we have visited. The question is, why do we visit temple? Because we have got some sort of attachment and desire to want to go to a temple and pray at a temple. The truth being that Sabarimala is actually not a temple of that nature. This is not a temple that you actually go visiting to say that I want a job, I want to get married, I want to have a child. God, I'm having a terrible time in life. Why don't you do something to get it improved? So this is not a temple in that nature. This is a very specific sort of temple, which is one that you would visit at the end of a certain fasting or vratam period. So there is a period of penance. You conclude that penance by going to this temple. So that is the basic purpose of the temple. As religion would sort of, as somebody who is wanting to practice the religion, therefore you would say that you have undertaken the penance and you now want to go to the temple and you are being prevented. The thing is that the visit to the temple is restricted to anybody that has not done the penance. It's not meant to be a temple that you could just get up and walk up to. So both men and women are prevented unless they have actually done the penance. So there is a 42 days of penance.
I would slightly disagree, although women at a later stage can go, and it's mainly about what I was reading about was women who were menstruating, that those could not go to the temple. And when you're said that, and when it does become kind of an equality issue as well, that's my viewpoint. But
so that's why I made that point about equality versus religion. It is not debated as an equality issue, and it is a much longer debate if you want to debate the equality issue. But it is about the right to practice religion. So people wanting to practice the religion, which means that for that specific tradition, you actually do a vratam and then you end up going to the temple, which is the pinnacle of that entire process. So if somebody has not done the first 40 to 41 days, to say that I want to go to the temple, it is not permitted. Now, this is true for both men and women. It's not specific only to women. So if you have not done the 42 days vrata, you should not be going to the temple.
So
by and large, I would say that is how you will view the restriction, and there are many facets to it as to why. When it comes to menstruating women, just to sort of clarify this, what happens is that the 42 days is required to get a devotee's mind to a certain level. So you do a fasting, you do prayers, you do lots of abstinence. It is meant to bring down your mental equilibrium to a certain level, which then culminates in you visiting the temple. Now, not being a woman, I don't know how you get hassled by an instance of menstruation. But let's say for men, it is equated with somebody in the house dies. So you have a sudden burst of emotion, or there is a child that is born. You have a burst of emotion. All these bursts of emotion distort the mental equilibrium, and therefore, those people, let's say you have a death in the house, you have a birth in the house, the men are also prevented from going, because the essence is that you're not able to complete the entire 42 days of bringing your mental state at a certain level. And that, therefore, when women menstruate, it again has the ability to disturb the mind space. Now, the obvious question is, one that I asked myself is, what if women pop up will delay their menstrual cycle and then go visiting? And I've asked this question of various mystics, and they say if a woman is able to do that, then I guess there is nothing to prevent her from going. So it's not, I think there is a 1950s law which has that particular rule that the Supreme Court struck down. But I think it's a little more convoluted and not as simple as just saying that women are not being allowed.
I guess, and the debate will go on and on and on. So
debate will go on and on, whichever way the Supreme Court rules.
So can I come back to CAA? Mr. Rakesh Gupta was asking that his understanding is that the government action does not violate fundamental rights by excluding Muslims. Kindly give your views, and we'll quickly then move on to the next.
No, that is correct.
Okay.
Which is why I said that the likelihood is that the amendment will get upheld in the Supreme Court.
Okay, so we come back to this, well, I can call it gender inequality in one way. So when she started practicing law, Justice Sujata Manohar, our second female Supreme Court judge, was asked if she was out there looking for a lawyer husband in the courts. Our judiciary is called male, pale and stale. Why is it so difficult, sir, for women to get into the legal system?
So I don't know Sujata Manohar's experience. And I guess it is when you say, are you looking for a husband in the courts, it's somewhat lots of, in a workplace which has got both men and women working, there are lots of instances where people actually get married over there. So there's nothing unusual about a woman finding a husband in the court or a woman finding a husband outside the court. It is incidental that lots of people that work of opposite sexes that work in the same workspace, you'll find in almost every workspace that there are people that actually get married.
So basically the point is that it's a male-dominated profession and women are not really encouraged there or given chance to grow. So, and that's why it's called a male, pale and stale kind of profession. Why is that?
So I would say, like almost every other public facet of life, which is male dominated. So there is nothing which is unique about the law being male dominated. So when you look at the world of business, it is male dominated. When you look at the business of hospitality, male dominated. So there is a lot of male domination that is a facet that is sort of historical in nature. What is happening is that is beginning to change. And I would say that the legal profession in particular is changing fairly rapidly. So there's a distinction that I would make. I would say that when you look at the legal profession, when it is court-oriented practice of law, that is where you will find lesser number of women, or you will find the women not held in the same regard as men, and I'll explain that. But when you come to practice of corporate law, which is what I did, you will find that lots of women are extremely powerful in when it comes to corporate law practice. So you will find that if you pick the top 4 or 5 law firms in India, you will find at least 2 or 3 of them led by fairly powerful women. But having said that, so I think the question is really, why is it in courts that women find themselves on the back foot? So there are 2 aspects to it. Advocacy, like many other professions, is basically driven by clients coming to you. So the problem lies in women being able to actually, it's not that they get unequal treatment in court. I think the problem lies in the clients not having confidence in women. So if you have, because prejudice exists in society, and if those guys are clients, then they come with their prejudice. And so therefore they pick lawyers as per those prejudices. That is true even so if you are a South Indian lawyer that is practicing in Delhi, you have a problem because the North Indians are not so happy coming to a South Indian lawyer.
What about you?
So I faced that in my early years. I'm South Indian, so I would find a problem with North Indian clients preferring to go to North Indian lawyers.
And women, they prefer to come to you for their cases?
So women...
You support...
See, ultimately, as I said, it's a question of what is the kind of confidence that a person has in a particular profession when they go on a hire. So if there are men that have confidence in a particular woman, they will go to the woman. So I've not noticed it very clearly as to whether women come more to me or women go to more to other women. But I would say, at least when it comes to practice of corporate law, around the world, there's a push for general counsel and in-house lawyers to be more women or coming from minority communities. And therefore, when you are a woman lawyer practicing corporate law, you're probably a slightly better place than men in certain circumstances, not always, but in circumstances, you are actually probably better placed than men when it comes to but having said that, I've had plenty of women that have been clients of mine as a corporate lawyer, so I have not seen so much of sort of the discriminatory part. But you're right, if you do a statistical count, you will find that there are a larger number of, and when it comes to disputes practice, larger number of successful men in legal practice than women in legal practice. And I would say that the problem is not from the manner in which the courts behave. The problem is more in terms of how society looks to hire their lawyers.
Archana, I think there are a couple of questions and people, sorry for interrupting.
Yeah. So I was just about to ask my next question and then go to the mixed bag of questions, because there are questions.
I think there are a couple of things which are related to the agility in the legal system.
Okay, so I'll address the questions first.
Okay.
I'll go backwards now. Pranav says, my view of the CAA is that while Mr. Prasad is right, and that every country has every right to decide who are two citizens if they are not already so by naturalization or birth, the fact that Muslims have been excluded is because they are not minorities in the persecuted countries, as Sikhs, Jains, Hindus, Parsis, Buddhists are in the countries that they have been persecuted in. Your view?
No, he is absolutely right. So from a constitutional sense, though the law does not talk about persecuted minorities, so the amendment itself does not talk about persecuted minorities, but he is absolutely right, is that in the neighboring countries, and it is interesting because it's not all neighboring countries. It is Bangladesh, Pakistan, and I don't think Afghanistan is neighboring because we don't have a border that touches Afghanistan. It is interesting because when you look at, as a South Indian, I would say that, let's say I was a Hindu from Sri Lanka, and all of us know that the Tamils have been discriminated against in Sri Lanka. This law is actually not allowing them to come in. The Hindus from Sri Lanka to come in with the same degree of enthusiasm as it is allowing Hindus from Bangladesh or Hindus from Pakistan to come in. So I would say that as a South Indian Hindu, I would say that it feels as if being South Indian is not a very good thing in this country. So there are discriminatory elements But as I said, it doesn't. It is more theoretical. A lot of this debate is theoretical. It doesn't impact any of us who are Indian citizens.
Mr. Kamal Batra is asking a very interesting question, useful for all of us. How does the WorldSpa case move with the government taking over Unitech? Do you think we can now move quickly to take over the shop situated on the west side?
So now you have the courts have appointed an independent set of board that has taken over. The board only means that the people who take decisions in Unitech are different. Their rights vis-a-vis the WorldSpa residents continue to remain the same as they were. I think WorldSpa is doing something to have a conversation with those people and get some favorable views from them on a certain set of things. Shops, as I understand, is not the immediate priority. The immediate priority is more about getting occupation certificates, because some of the towers, particularly on the beach side, on the west side, don't have occupation certificates, don't have completion certificates. The clubhouse doesn't have completion certificates. So those are the things that actually WorldSpa is currently focused on with the new board at Unitech.
And Mr. Rakesh is asking further to the question by Mr. Goyal, can the adjournments be limited in numbers and timeline of next hearing be shortened? So Mr. Goyal was asking that large pendency of cases and time taken to get judgment is too long in India. Do advocates play a fair role to reduce the time of litigation?
So Mr. Goyal is absolutely right, and Rakesh is absolutely right. There is a problem with the manner in which adjournments happen. There's a problem in which, of the manner in which, I would say the lackadaisical manner in which people agree for adjournments. So most lawyers approach it by saying that sometimes I may need adjournment and sometimes I don't want adjournment, still agree to it because when the other side asks, because there would be occasions where I would need an adjournment and if I have the other side pushing back. So yeah, there is a bit of a lawyer play in agreeing to or not agreeing to adjournments. But I would say a larger responsibility is that of court, because I can ask for what I want, but ultimately it is the court to grant me what I want. So courts have got to be a little more enthusiastic about getting the job done in as short a time as possible. And there are a whole host. It's not as easy. The answer lies in a whole different host of things, and it'll lie in the degree of reform that is required in judicial administration, in the procedure codes. I think the use of technology, particularly when you're video conferencing, that's where you'll find that the need for adjournments or the demand for adjustment will go down. But let's see how it transpires. But you're right, absolutely. As of today, adjournments are a big pain for litigators.
So Shuchi is asking you that she would like to have a discussion on Section 56 of Contract Act and how it recognizes force majeure irrespective of wording of the contract. Also the deemed force majeure of COVID based on government's notification.
See, off the top of my head, I don't know what Section 56 says.
I wish I could help.
But there is a concept called discharge of contracts, and one of the bases for contracts to get discharged is if it is frustrated. Now, if performance is frustrated for any of the parties on account of force majeure, and this is the force majeure situation, is that the contract will be discharged. Getting discharged, in layman terms, I'd use the word terminated, but it has the same effect as termination. So it is terminated without consequence. So nobody is found to be in breach of contract, but the contract was said discharged. Unless you agree that the contract should not be treated as discharged.
Hi, sorry. Can I just take 1 second?
Yeah, sure.
Specific thing. Sorry to interrupt. Yeah, no, this point was very interesting, and that's why I wanted to discuss it, because what Section 56 really talks about, that's the contractual recognition of force majeure, but it's a very specific recognition which says that any part of the contract or the entire contract which is impossible to perform is deemed to be void and no penalty can be imposed by the other party. And to move along on that, the government has actually issued a notification to say that, suppliers who are not able to supply, for instance, you have supply contracts, they are able to cite COVID as a force majeure, so that they don't have to pay penalties because they are in breach of contract and they haven't done their part of the obligations under the contract. So I just wanted to raise that point because, not always, even if the contract doesn't specifically provide for force majeure, we do have Section 56 to give us some comfort there, where if either at the start of the contract when it was executed or at any point of time during the contract, it becomes impossible to perform something due to a natural calamity, due to forces beyond control, then there is no breach of contract. I think that's the legal principle that we do have to give us some comfort, even if the contract doesn't mention it. COVID has a specific notification.
So like you said, actually 56 is exactly what I was saying. It actually says that you're discharged. When you say, you could use different terms. So you could say that the contract is voided. But basically it is discharged, and it is discharged as if there is no breach. So there is no liability. It will not be treated as a breach of contract. And like I was saying, unless you have the two parties agreeing, or there is some law that allows you to bridge the gap and allow continuation of the contract. So if there is a COVID specific notification, I don't know under what provision of law that, or whether the notification is going to be legally valid. Because the notification, you can't just execute, you can't just issue executive law. Law has to come through parliament or through an ordinance. So I don't know if they're doing a notification has to come under some law. And the contract law doesn't allow for issuance of notifications of this type. So I'm not sure. I guess that will require a more involved discussion, me having a look at the notification. It may be that this is a notification issued under some other very specific laws that allow for notifications like this to be issued. Notification may even be advisory in nature. It may not be binding. I can
forward it to you, not a problem. I can forward the notification to you if
that'll be nice. You can take it privately now so that we can also now go on.
Yes,
thank you, Shruti. Thank you, Anand. We'll go to the next question. PC asks you, why should the court have a recess? The British are gone, and so is the need to go to cooler climates.
So, when you are, if you are in a cold country, they still have a recess. So, climates have nothing to do with the need for recess or not. The question of recess is, do most of us like to go on holidays? And if we do, to insist that there should be a bunch of people that should never be entitled to go on holiday is slightly unreasonable. But having said that, I think there are ways for, like government continues, when not everything is locked down, you could have a situation where judges can periodically from time to time, regardless of a specified period, a set of weeks where almost everybody disappears on a holiday. So you could have something like that. I think there is, courts, given the backlog, have started to think somewhat in those terms. But nothing has happened as of now.
So, Anand, your point is valid, but the whole thing is that justice gets delayed. And Rakesh is now asking that how do we speed up the process to dispose cases quickly? The backlog is so huge that justice delayed is justice denied.
So this is somebody else asked me to do a presentation on how do you speed up the justice process, and I said it will require at least 2 different lectures of 1 hour each to sort of talk about how do you speed up justice system, because there's a lot of process that you actually need to fix. But in short, what I would say is, I would say, if you start applying technology, you have to understand or appreciate that most of our legal system is set up at the time of the British Raj, where the population was significantly lower, and society was very different. It was. I think so many violations, so many breaches were not there. The society was, as a result, not as litigious. People are nicer in those days. People are not so nice these days. So the need to seek recourse to law is much more, and as a result, the system that had been set up in the past can't actually carry that load. There is a need to deal with that load. There are a set of processes that you need to put in place. There is a deployment technology that you can bring in. So, like for example, video conferencing. But other than video conferencing, you could actually deploy artificial intelligence. So you could, for certain simple kind of cases, and that's again a view that I have. I'm not saying that government is considering it just now. But for simple matters, there's no reason why you should actually have a physical judge sitting out there. You could quite easily create an algorithm that deals with some of this. And if people don't like the outcome, they can go and appeal. Now, this is not unique. I'm not sort of creating it out of the air. In the UK, they have actually started using artificial intelligence for certain kinds of cases, motor vehicle cases. If you just Google artificial intelligence in courts, you will get some of those, and working quite well. So there is a move, and it's not only India that faces the pressure of the volume of litigation. Around the world, the volume has gone up. So there is one element in terms of just how do you use technology. There are various other ways of using technology. The one other way, and this is sort of more, it talks about, so when you compare it with the US system and when you look at the Indian system, why is it that the US system, even if it's somewhat similarly treated as India when it comes to use of technology, why does it work better? It is because in India, the cost of violation or cost of breach is next to nothing. Whereas if you lose a case in the US, the costs are colossal. So you could, if you violate some compliance requirement or if you breach a contract, you could get hit down very badly. Whereas in India, you would get off with a 6% interest cost. So if I have to give you 100 rupees, I'll take a call. Is it better for me to give 100 rupees now, or should I just keep the 100 rupees and give it to her when she gets a court decree? Because if I had to go and borrow the 100 rupees, the bank will probably charge me 10, 12, 15%. Whereas if I look at it in terms of cost, to Archana, I just need to give 6%. That is the kind of cost, 6 or 8%. So it is cheaper to breach a contract. And I think that's the paradigm that needs to change. It can't be inexpensive to breach a contract. It has got to be significantly more expensive. So that deterrence is not there under Indian law as of today.
Last question before I move on. Mr. Banga is asking, do all the donations in cash or kind come under CSR, or is there benefit under Income Tax Act?
So I would imagine that cash contributions to a certain level, and I think it is, if I'm not mistaken, it's about 2 lakhs, would be permitted in a year, because cash dealings are actually restricted today. So you're required to actually deal more through formal banking channels rather than the crack. So CSR gets calculated in terms of what your balance sheet looks like. And therefore large amounts of cash will not, the reason why it is cash is not on your balance sheet. So small amounts, which is petty cash, you can show on your balance sheet, and therefore you can use it to sort of put in for CSR. But those will be really, really tiny businesses if you're talking about up to 2 lakhs. The large amounts of cash will need to go through the balance sheet, and if it is off balance sheet, then how does somebody calculate that you have even contributed it? So that's the practical element of why cash does not work for CSR.
Now it's about you, Anand. You formed a party called the Liberal Party of India. Who else was a part of this, and why did you not continue?
So they were when we started, I got involved with political activity in the early days of the Aam Aadmi Party. So the Aam Aadmi Party had just been formed, and within a month I sort of got involved, and I had this huge frustration in terms of the corruption situation in the country, the manner in which the judicial system worked, and the manner in which the bureaucracy works. So in my mind, there was a need for significant structural reform in the country for things to change, because otherwise it is band-aid measures. We talk about little changes here, little changes there. It doesn't really work. We need structural change in the country. My early experience in the Aam Aadmi Party was disappointing. I didn't think that the party was, and my apologies to my friends who are part of the Aam Aadmi Party, but But a bunch of us actually came out of the party at that time because we were not sure that the Aam Aadmi Party was enthusiastic about structural change and about bringing real change. It had a very limited approach to say that as long as you're financially honest, everything else will fall in place. And many of us didn't agree with that. And so a bunch of us went on to put together a new party, which is called the Liberal Party, which was set up in 2017. But at least my experience with the Liberal Party, I realized is when you talk structural change, it works more amongst the community like ours or people that are sort of more educated. It has no comprehension of the common manhood, and it's not the common man's fault. The common man lives on a day-to-day basis. He's thinking about how his tomorrow is going to happen rather than in terms of structural change. So structural change has no political acceptability when you fight elections. And so that realization resulted in me saying that all right, it means that India will only get incremental change because that is how the voting population thinks and works. And so therefore, I thought that it is better for me to do other things that I'm more effective at rather than.
And yes, I'm going to ask you, why do some people in Valspa refer to you as Dr. Anand Prasad? What are the other things that you need to do?
So I need to get a PhD before I'm entitled to be called a doctor.
Okay. Why do they still call you?
So that is just boys pulling each other's legs.
Okay. But you also have some valuable contributions to the Rockstar group. What is that about? And you want to share some with us?
So the Valspa Rockstars group is a WhatsApp group of some of the men folk in the Valspa. Many of them are on this chat. And people behave like boys.
Don't spill the beans.
It's still active, I think.
People behave like boys on the group. So everybody behaves like a teenager.
People have FOMO, fear of missing out. FOMO. Yeah.
Okay,
See, I've been digging out information like you.
Can I
Born you like a lawyer.
It's actually more popular than the ladies group.
Can I ask one question?
And I'm sure after this talk, it will be, in fact.
Can I ask Dr. Prasad one question, please, if you don't mind?
Yes,
Sure, quickly.
No, very quickly. By the way,
Music hour is about to start, remember?
Yeah. By the way, Dr. Prasad, Archana is my sister, so that's how she's getting the information. Just.
Right.
So anyway,
Yeah, and you had to announce it, right?
हाँ ठीक है कुछ नहीं होता. अच्छा सुनो. So the question, Dr. Prasad, I want to ask you. In the past, I've heard that you were planning to take some delegation from Valspa to Nepal to study the legal system over there.
The Valspa delegation of Valspa to what?
Nepal.
Nepal.
Nepal. Okay.
Okay, so we finish off with the last question. What is your advice to the youngsters of Valspa who want to become lawyers?
So I think the practice of law is very interesting. Even studying law is very interesting. There are new things that you learn. I would say for people that want to seriously practice law, ask yourself whether you actually enjoy the whole idea of dispensation of justice. Do you enjoy the idea of fair play? Do you enjoy the idea of bringing fair play to other people's lives? If you like it, then you will enjoy the practice of law. If you do it because it's just another profession that you could indulge in, you will find you might become fairly successful at it, but you'll feel that it is burdensome. So it is my sense would be do things that you enjoy doing, or do things that you, even when you start studying, you'll figure out whether you enjoy doing it or not. I've met many people that became lawyers just because their parents or somebody else pushed them to it, but they thought that it meant one thing whereas it meant something else, and then they are not so happy, so to say. So I would say that just see whether you actually enjoy the idea of justice or fair play, and then take a call on whether you want to be a professional lawyer based on that.
So this last question I cannot resist. I was about to end. PC is asking you, can Atul be prosecuted for loud music? I will definitely defend him because he's my brother, but she's asking me if I'll defend him. Of course I will. So
I'm asking
So the answer is twofold. You can prosecute Atul under a tortious claim to say that I'm entitled to peace and Atul is disturbing it. So he should give me, for each day that he violates my peace, he should give me 1 lakh rupees.
I'll go with a drink. Actually, he needs to give me a drink.
A drink is also good enough. So you could do that. But there could be other slightly more serious provisions of law that you kick in. It will then depend on whether sort of the nuisance rises to a certain level of criminality. So you could have situations, and I'm not talking about just the music that we guys play at around 6 o'clock, but you could have a situation where noise becomes a nuisance that attains a degree of criminality, in which case they can be criminal prosecuted.
So someone is sending me a message that he is too cute to be prosecuted anyways. So I end with this, and so thank you everybody for coming and attending this session. It was very interesting, and thank you Anand for giving us your valuable time. Thank you. And tomorrow we have 4 people: Sangeeta Pal Gupta, Rohit Hari, Pankaj Raj, and Ashutosh Khanna. And they're going to discuss the job scenario post COVID-19. So a lot of us are going to be there. And now, thank you everybody once again.
Good evening. We still have 5 minutes.
Yeah,
but we
run out of questions.
And
Atul wants to speak.
Right?
I want my answer on this delegation to Nepal. I mean, to study the law.
That we'll take
Atul
up
will
from
take
the
it offline.
Because the
members are still
music
waiting. The members are still waiting to go.
Yeah, Atul will take it
The
offline,
music
and
is
with that,
going to be low, so we'll discuss it from the balconies.
we'll take it offline, and with that, I'll close the meeting. Thank you.
Yes.
Bye.
Thank you.
Thanks,
I got 5
everyone.
minutes extra to play now. Okay.